So as mentioned, I'm Bridgett Simmons. I'm with the National Housing Law Project. NHLP is a national policy advocacy organization. So all of our advocacy is informed by the Housing Justice Network, or HJN for short. It's a national network of over 1,500 housing advocates, mostly of which are legal service attorneys. And so we became involved with the implementation of smoke-free housing because we work on policy around affordable housing with HUD subsidized housing in particular. And so, you know, we definitely support the public health aspects of this rule, but we also want to make sure that those that are most vulnerable in terms of housing stability also can remain housed. And so we are drafting a manual about equitable and effective implementation of the smoke-free public housing rule. And so today I've been invited to talk about some legal questions and concerns that we've seen throughout the first year of the implementation of the smoke-free rule in public housing. So we can go to the next slide. So this is just a brief overview of the smoke-free rule. So in 2016, HUD published its final rule instituting smoke-free public housing. So the rule requires that housing authorities administer and design its local smoke-free rule, and housing authorities were to have that rule in place by the end of July of last year. So the places that HUD said that smoking should be prohibited are in the residence, so common areas, as well as personal units, office buildings, and then also 25 feet from residential and office buildings. So smoking, what products are prohibited? So once again, an overview: cigarettes, cigars, pipes, hookahs. PHAs can choose to exclude or include electronic nicotine delivery systems as part of their policy. So HUD chose not to include what they call ENDs. So ENDs are like vape pens, e-cigarettes, electronic cigars, all of those varieties. But local housing authorities can choose to include ENDs as a prohibited product in their local policy. So as I mentioned before, housing authorities were required to have their policy in place by the end of July 2018. So how are housing authorities and residents, like what are the roles and responsibilities of the housing authorities and the residents? So housing authorities had to, one, develop their local policy. And so that required the amending of the PH plan and the ACOP. So HUD has indicated that the adoption of a smoke-free policy is likely to constitute as a significant amendment or modification of the PHA plan, which requires a public meeting. So when PHAs adopted their smoke-free policy, it requires that the public had an opportunity to give comment on that plan. And so it's important that housing authorities went through that proper process, because if the proper process was not taken, that opens up an opportunity for folks to not necessarily challenge the policy, but to challenge the housing authority's process for adopting the policy. And then also, all notices to tenants regarding the smoke-free policy are subject to fair housing and civil rights requirements. So thinking about the notices that went out to tenants, it had to meet the LEP requirements. So the language needed to be to clearly communicate to residents the purpose of the smoke-free policy and what the smoke-free policy requires of tenants. And then also that communication to tenants needed to be in a way that was accessible. So various residents have different levels of accessibility. And so in particular, for example, for those who have a visual impairment, that notice needed to convey information in a way in which they could receive the information. So in the next couple of slides, I'm just going to highlight some enforcement and implementation legal concerns. So the first topic is electronic nicotine delivery systems, which HUD refers to as ENDs. So as I mentioned before, HUD has not prohibited the use of ends in its policy. So that means that housing authorities have the option of including ends or also excluding ends from their smoke-free policy. And so once again, ends are this electronic device that users inhale and subsequently exhale a heated aerosol. And so each company has its own recipe for these aerosols, but they typically include nicotine and other cancer-causing chemicals. So HUD indicated that it did not include ends in its policy because the research to date of the rule being passed was still developing and lacked clear consensus in contrast with the research around cigarettes and other tobacco products. But HUD did indicate if the research, if that research became consistent in the harmful dangers of nicotine, the electronic nicotine devices, that it would amend its final rule. And then additionally, HUD felt that ends cause little to no damage to the actual unit. So two of the reasons that HUD decided to implement the smoke-free policy is one, the dangerous effects of second and third hand smoke, and then also because of the cost to local housing authorities of having to turn over a unit where a smoker formerly lived. And HUD expressed in its notice of its final rule that ends did not quite meet up to its level of concern in those two areas, and so they chose not to include it in the final rule. So traditionally, ends have not been used as a cessation tool, but some housing authorities have allowed residents to use them in order to increase compliance or as a reasonable accommodation, and I'll talk about a reasonable accommodation shortly. And so although ends do not present the same risk of causing catastrophic fires, they have been known to explode and cause fires when they're not properly used. So in instances where the device has to be charged and it's left charging on a piece of cloth or like on an ottoman that is cotton, they've been known to explode and cause fires. And PHA should weigh all of these factors when determining whether to include e-cigarettes as part of their prohibited products in their smoke-free rule. Okay, next slide. So the next thing I wanted to talk about is the 20-foot radius. So in addition to being unable to smoke within the property, so within the unit, in the common areas, residents as well as staff and guests to the property cannot smoke 25 feet from the building or up to the property line. So some properties, the lot size doesn't allow for a 20-foot radius from the building. And so those properties would only have to enforce the smoke-free policy up into the property line. So PHAs also have the discretion to designate areas outside of the 20-foot radius as smoke-free. So example, if you maybe have a playground on your property that is beyond the 20-foot radius, you can say, okay, around the playground, you cannot smoke as well. And then also PHAs can also designate their property to be completely smoke-free. Where possible, we have advocated for having a place on the property where smoking is permitted, just because this increases compliance with the smoke-free policy. Residents know exactly where they can smoke, and so it just increases folks being willing to be compliant. If there is space on the property beyond the 25-foot radius, and there's a space that housing authorities would like to be the place where smokers go, that place should be clearly marked. Even if it's not a designated smoking area, the 20-foot radius from the property building should be clearly designated or marked, indicating that beyond this radius, beyond this line, that is the appropriate place where you can smoke. And so properties with sufficient ground area might decide to create a place called the designated smoking area. And so in that DSA, smokers would smoke in that area. And some properties, they have created structures, so maybe like kind of like a pavilion where the folks can be protected from rain or other elements. And so the only thing about raising a structure I would, want to flag for folks is that you have to be sure that the structure is not considered a building under state and local law, where the state or the local locality has a smoke-free policy. So many states have a policy of you cannot smoke in buildings, and so you just want to make sure that any structure that you raise is not considered a building under the smoke-free laws. And then properties that don't have enough space beyond the 25-foot radius, or has a parcel that doesn't have a 25-foot radius to the property line, should partner with neighbors or local municipalities to identify a place nearby the property, a public area where residents can smoke. And so obviously, I mentioned, the smoke-free policy is up to the property line. If the parcel it doesn't have a 25-foot radius. So you want to discourage any of the residents from trespassing onto neighbors' property. So, you want to work with your neighbors and inform them of the smoke-free policy and letting them know that residents now have to come out to smoke because the rule will have an impact on neighbors. And then finally, wanted to mention that designated smoking areas should be inviting and accessible for all residents, including those with various abilities, and then also accessible throughout the year. So to the next slide about enforcement. Housing authorities, so HUD has left it to local housing authorities to develop their local process for enforcement of the policy. However, HUD has instructed PHAs to use tenant leases as the method of enforcement. So that means that a smoking incident would be a violation of the lease. HUD has stated a violation of the smoke-free policy should be enforced in the same manner as any other civil lease violation. So the first topic under enforcement that I wanted to discuss are fines and fees. So in the public housing context, fines and fees can only be levied in limited cases. So when the PHA is charging the tenant for tenant-caused damages, so tenant-caused damages, excess utility usage, late fees, and security deposits. So any tenant-caused damages would have to be beyond normal wear and tear and would have had to be committed by either the tenant, a tenant guest, a member of the household, etc. So the final smoke-free public housing rule does not expressly authorize or prohibit the use of fines. We've seen some housing authorities use fines as a method of encouraging compliance. And some housing authorities, they've charged a cleaning fee. And so I also, in terms of fines and fees, non-payment of an extra charge, so like a fine or fee, is not good cause to justify an eviction for non-payment of rent. So if someone doesn't pay a fine or a fee, an eviction notice couldn't state that the tenant hasn't paid rent. So a fine or fee is not considered rent. And then the fee doesn't become collectible until 2 weeks after the PHA has given the tenant written notice of the charge. So I say all of that to say, some housing authorities have used fines and fees as a method of enforcement, but for housing authorities that have chosen to use fines and fees, they have to be mindful of the various procedural protections that are afforded to public housing residents in terms of levying those fines and fees. So other housing authorities have chosen to use nicotine monitors and kits. So there's a slight difference. Monitors react to changes in the air quality, whereas kits require a collecting of a sample. Most housing authorities do not use them because they tend to be cost prohibitive for PHAs. And so if a housing authority is thinking about using a monitor or a kit or air quality monitor, it's important that the housing authority and the staff are well trained on how to maintain and use the kits and monitors, just because they could be, you know, challenged in court if they're not properly maintained, because if some of the monitors need monthly or yearly maintenance, and poor maintenance will impact the response of if the monitor or the kit or detector is picking up nicotine in the unit. And then another thing to say about kits and monitors, some of them will give an immediate alert of detecting nicotine in a unit, while others will require testing in labs. So that goes back to these tools being a bit cost prohibitive for some folks. And then the use of monitors and detection kits must be done in a manner that's consistent with fair housing requirements. So housing authorities and staff can't just put monitors in the units of people that they know smoke. That would not be in a manner that's consistent with fair housing. So if a housing authority decides to use these monitors and kits and detectors, they have to beforehand develop a plan of how they'll be placed throughout the property. So then I want to talk about establishing violations and then graduated enforcement. So HUD has indicated that graduated enforcement is a best practice that they encourage each public housing to use to enforce their smoke-free policy. And so what is graduated enforcement? So HUD has indicated that a single violation of a smoke-free policy is not good cause for an eviction. And so they're encouraging housing authorities to use graduated enforcement to encourage compliance with the smoke-free policy, and to strike that balance of enforcing the policy, but then also making sure that folks can remain housed. So for graduated enforcement, for each violation, there's an incremental step that reminds the residents that there is a smoke-free policy in which they're required to abide by according to their lease. And so for each step, the staff would, so usually it starts off with a warning, then a warning and a verbal warning, then a written warning. And then with each incremental step, there's an increased compliance a mechanism along with the reminder of the smoke-free policy and what it requires of the residents. So we've advocated for in a graduated enforcement for there to be at least 3 to 4 steps before an eviction is pursued. And so for each incremental step, housing authorities have paired like the warning and the consequence with resources that are provided in the community. So like if there are local cessation resources, or if, so in some areas there are like smoker folks who are trying to quit, like support groups. So just informing residents of these various resources that they can use in order to be in compliance with the smoke-free policy. And something else that we've encouraged is after a set amount of time, so say if a resident goes 3 months without another incident of violating the smoke-free policy, that the clock resets. So they if there's another violation, they start back at step 1 rather than at step 2. So a graduated enforcement is just an increasing of the consequences before eviction is pursued.
Bridgett, I'm sorry to interrupt. We actually are out of time.
Okay.
Everybody will receive a copy, of the PowerPoint afterward, and I'll update it with the correct title of your presentation. But was there any last thoughts you wanted to leave to people? You wanted to be sure to mention that people hear?
Yeah, so then the last thing I really wanted to flag was about reasonable accommodations, and I'll just say that, housing authorities should look at each request for a reasonable accommodation individually and consider each individual request, and that a request for a reasonable accommodation isn't a request to accommodate the smoking, but the underlying disability that makes it very difficult to comply with the rule. And so I think in the PowerPoint, I include various examples of how reasonable accommodations can be paired with smoke-free policies.